Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
Well, you can say the most important variable that we are going to use, or the most important concept, or you can say variable, that is created using this shareholder rights. In this case, we're looking at shareholder rights. So, by comparing these cash flow rights and voting rights, this measure basically says, well, we can measure the magnitude or the degree that minority shareholders could be expropriated. Right? So simply saying that if the cash flow rights is smaller than voting rights, then it means that some shareholders have disproportionately larger controlling power than what they own. Okay? So even if they own maybe 10% of the shares, they could have like 15%, right, of the control. So that's what it means. So a simple example is preference shares, right? Because these shares don't have the voting rights. They have the rights to receive the dividends, but it doesn't have the rights to, vote. So if you have this kind of voting rights, if you have this kind of shares, then obviously, on average, right, the owners of these the regular shares, ordinary shares, have more voting rights, or voting rights compared to the average, right? So that's why we compare this cash flow rights to voting rights. So this is the result I was showing you last time. And if I go, if I may review this again. So this is panel A is cash flow rights and voting rights. And this is of, this is of the, you're looking, this graph, this figure is looking at the largest controlling shareholder, okay, of, let's say, in Hong Kong. So they look at 330 companies, and they look at the largest controlling shareholder, and then ask, what is the proportion of the, this cash flow right is equivalent to ownership, so what is the ownership, right? So it means that the largest controlling shareholder, in this case, largest means it's at least has 5% of the voting rights, have ownership of 24% in the mean. But if you look at their voting rights, the voting right is actually larger, 28%, right? So which means that the voting right is greater than cash flow rights for these largest controlling shareholder. And by taking this ratio is 0.882. This is the ratio, cash flow ratio to voting rights. So if the voting right is greater than cash flow rights, this ratio becomes smaller, right? If it's like, if they're equal, then it's 1, right? So that's how you look at it. And so, and in case of Japan, this is the lowest, 0.602, but as I mentioned earlier, this is probably due to the preference shares. Okay? But we'll talk about why these voting rights can become higher. Okay? There are different mechanisms that make these voting rights greater. So we'll talk about this next week. Okay, we'll talk about this mechanism next week. But here we're basically looking at this difference and how this, affects the minority shareholders. So you can say, general investors. So this is what we were talking about. Okay, so this is an example. I mean, this is just taking Hong Kong as an example. Then I'm explaining these numbers. Okay. Ooh. What's happening? Well, here it says system busy, please wait. So I'm sorry about this, but I don't know what's happening. There seems to be a lot of problem with this classroom, with this system. Is it similar in other classrooms? No, it's only this classroom? Because we've been having this kind of a problem since the beginning. Okay, good, yeah. Okay, thank you. Okay, anyway, so any questions on this table? Okay. All right, so now what we do, well, not we, but what we're going to see is this famous paper, LLSV. So LLSV is is coming from the 4 authors. Okay, so okay, let me see. Where are they? I haven't typed out the names. Okay, I'm sorry. Yeah, I haven't typed. This is. This is the first one is Laporta. The second one is a very long name, which I don't remember how to pronounce. And the third one is Schleifer, and the fourth one is Vishny. Schleifer and Vishny are very well-known economists. Schleifer is from Harvard. Vishny, I think he's in Chicago. Okay, but so this is a very influential paper that they wrote in 1998 in Journal of Political Economy. So this is one of probably one of the most important readings in in this course. It's a required reading. I don't expect you to read and understand everything, but once you know what the paper is doing, then it's much easier for you to understand. And so this is probably the first paper that showed that the origin of law, you can say it's the legal system, a difference in legal system matters for companies' financing or ownership and all these things. So basically, you can say companies' financial behavior as well as ownership structure. So these things can be determined by the legal system. So how do they compare the legal system, right? So because the legal system is, is same. I mean, for each country has a legal system, right? So to compare, you have to compare across countries, okay? But here, they have classified the countries, or you can say the legal system, into 4, okay? So one is so-called common law countries. And these are mostly common law, so it's coming from UK, British. But then, as you can see, most of the countries were former colonies of UK, is part of the British Empire. So they have inherited the legal system, right? Of course, US, didn't become a colony, almost became, but they still inherit the common law system, okay? And the next one is the German civil law countries. So this is again, it's a German, derived from this German law system. And Japan, South Korea, Switzerland, and Taiwan, and Austria, yeah, so they are classified into this group, okay? And French civil law countries, again, if you go back history, many of them are former colonies of France. So they have inherited the French civil law system. And the last group is the Scandinavian civil law countries, which is Denmark, Finland, Norway, Sweden. Okay. So they have classified these legal system. This might be coming from the legal studies, which I don't know exactly, but this is how they classify. But here, what they do is we have, as we have learned about this creditor rights and shareholder rights. Okay, so then this paper basically looks at these countries and look at all their creditor rights and shareholder rights for these countries, and then compare for these four groups. Okay, so that's the first step. So what does the shareholder rights and creditor rights look like for these four groups of countries? Well, of course, they look into every one of them. Yeah. Okay, and the countries that in bold phase are countries in this area, region, Asia and Australia, New Zealand. And at least I know, just vaguely, but the difference between common law and German civil law is that common law is based on precedents, right? So what happened in the past, how people decide, how the judge or the court decided on this ruling, and that's all recorded. And then in the next one, they will take this and what people had done this in the past, what was the decision by the court, and then that it's like a big database, right, of the past rulings. And then they use all these past rulings, and then also decide there could be some different situations happening, and then that's the way the court works. German civil law is slightly different. Everything is written down from the beginning. It's like a dictionary of law. Yeah, and then the court or the judge will decide, looking at this thick book, probably now it's computerized, they look at it, and then they will, decide, right? They make the ruling. So, there are, fundamental differences between these groups. Okay, I don't know much about French civil law and Scandinavian, but here it's not important how about this, but it's more important what is the creditor rights and shareholder rights in these groups. So let's look at this. So LLSB, they found that common law countries afford the best legal protection of shareholders. So basically they went through all the countries, right, and then they compared. Yeah. So they said 39%, say most frequently, allow shareholders to vote by mail. So 39% of the countries in this group allow shareholders to vote by mail. So you don't have to travel all the way to the shareholder meeting. And also, they don't block the shares, they deposit the shares before the shareholder meeting, okay? And they have the highest, 94%, incidence of laws protecting oppressed minorities, okay? And they generally require relatively little share capital, which is like 9%, to call an extraordinary shareholder meeting. Okay? And also the common law countries have the highest average anti-director rights of all legal families. Yeah, so anti-director right is to protect the minority shareholders, right, from either managers or the large shareholders, right? So that's the anti-director rights, which we went through on Tuesday. Yeah, so as far as the shareholder rights are concerned, common law countries have the best legal protections. Okay? And on the other hand, the French civil law countries has the worst among all the groups. So that's what they find. But what they do is basically, it's written in the paper, in this article, that they go through all these, all the creditor rights, shareholder rights, and then they basically, count the numbers. Okay. Creditor rights, and so it's a bit small. So common law countries offers creditors stronger legal protection against the managers. Yeah, okay. So for the creditors, the legal protection is good. Stronger, it says stronger, okay? Well, stronger than French civil law, but actually the German civil law countries are even more stronger. So their creditor rights creditors are even more protected. Okay? So for common law, yeah, so let's go through this. So they have the highest incidence, 70% of no automatic stay on assets. Okay, no automatic stay on assets, right? So it means that if there is automatic stay, the creditor cannot go in and possess the collateral, right? If there's no automatic stay, then the creditors can go in, right? Okay, so 72% has no automatic stay on assets. With two exceptions, they guarantee the secured creditors are paid first. Okay. The German civil law and Scandinavian families have no exceptions. So basically, in that sense, German civil law and Scandinavian countries, in these countries, all the countries have the secured creditors are paid first. Okay. And the third one, 70% preclude managers from unilaterally seeking court protection from creditors. Okay. So, so the managers of the company that is going into reorganization cannot ask the court saying, okay, please stop the creditors from seizing the collateral. Okay, so they cannot say, for 72% of the countries cannot, they cannot do that. Okay. And yeah, so the common law countries have the highest incidence of removing managers in reorganization proceedings. So this I explained Tuesday, that when a company goes into reorganization, which is a legal process, then the court typically appoints somebody else. Okay? And the managers of that company, the previous manager, cannot stay in most cases. And that is the case for common law countries. Most, okay? But here, there's a big exception, which is the US. So US, in a sense, is a bit of an exception among the common law countries, as it is one of the most anti-creditor common law countries. Yeah, so they don't protect the creditors that much in the US. It permits automatic stay on assets, okay, allows unimpeded petition for reorganization. Yeah, so they can go ahead, the management can go ahead and start reorganization. This is called Chapter 11, right? And yeah, lets manager keep their jobs in reorganization. Right? So that's why in the US is a bit of an exception among these common law countries. And for French civil law countries, it offers the weakest protection against creditors. Okay, so French civil law countries doesn't look good in this paper because they already have the weakest shareholder protection, but also the creditor protection is also weak. Right? So only 26% have no automatic stay on assets. Right? Common law countries have 72%. Right? And only 65% assure that secured creditors are paid first. Right? English origin, which means common law countries, 89%. And 42%, only 42% place restriction on managers seeking court protection from creditors. And relatively few, 26%, remove managers in reorganization proceedings. Okay. So that's the French civil law. So compared to the common law countries, the French civil law countries have the weaker or weakest creditor protection. And German civil law actually does have a pretty strong creditor protection. And so, as I mentioned here, right, at the top, German civil law and French Scandinavian families have no exception about secured creditors are paid first, so they are paid first. And automatic stay, right, is not allowing automatic stay, 67%, and letting them pool collateral. Yeah, so basically the creditors can go in and take out the collateral. And secured creditors, in all of them, are paid first. Okay? So that's why it's very friendly to the creditors, so banks and bondholders. And relatively few of these countries, 33%, prevent managers from getting protection from creditor unilaterally. Okay. So they don't prevent managers that much. Yeah. But actually 67% allow managers to stay in reorganization. Yeah. So that's a bit different from common law. But the thing is, German civil law countries have strong creditor protection. Okay? The background of this is Germany, right, has a very strong banking system, right? So nowadays, their stock market is also, developed, but historically, if you look at historically, the banking system is very strong, right? Like Deutsche Bank, Commerzbank. So, so that's why, in a sense, the corporations finance through banks more than from share market. UK is more, of course they have big banks, but the share market is more developed historically than Germany. So that's why the shareholder or the investing in shares has been more widespread in UK. So Germany is typically, said it's a bank financing country. So companies borrow more from banks. Okay. That is also true for Japan. The companies in Japan borrow more from banks. Okay. So, so that's why there is some, historical background, especially in Germany, and also Japan, that the banking system was more developed than share market. Okay, so basically, this is a creditor rights. So you can see that, right? Shareholder rights, creditor rights, common law countries, on average, they have better protection. Okay? Especially compared with French civil law countries. Okay. So the next thing is this, right? So, so as I mentioned when we talked about property rights, well, you could have a well-written law, but enforcement is issue, right? You need good enforcement. Yeah. It's like this, what I mentioned in this Sesame Street property rights. The parent has to be able to enforce the rule to the children, right? If the children don't listen to the parents, then there's no enforcement, right? So, so that's why the enforcement is important. So therefore, this LLSB looks at these 5 things. So first one is efficiency of judicial system. It's basically how long it takes to make a court decision. And the rule of law, right? And corruption, and risk of expropriation by the government. Yeah, so this could happen in some countries, right? The government suddenly steps in and takes away the assets. Well, this is like forced nationalization. Okay? And likelihood of contract repudiation by the government. Yeah. So the government comes in and say, okay, I'm sorry, your contract is no longer there, right? So something like this. So these, well, you can say that in these last 2 are more like, like a country risk that people talk about. When you invest in like emerging countries, sometimes the government could be toppled by, some other groups, right? And then the other group may take over the government and they say, oh, they seize the asset, right? Then if you're an investor in that country, you may lose what you invested. So that's more of an extreme situation, but these things could happen. Okay, so then I won't go into too much details of this, but law enforcement, the Scandinavian and German countries are the top. Okay? And these families have the highest scores of any group on the efficiency of the judicial system, rule of law, corruption, risk of expropriation, and the risk of contract repudiation by the government. So they are the best. Yeah. And common law countries are behind these 2 families, but still ahead of French civil law. Okay. So, so it means that the French civil law countries are also not good in this law and order. So that's their conclusion. Yeah. So law and order is, related to this. This is a bit small, but incidents like your investment, right? You invest in a firm. But then someone in the company or the government of that where the company is can steal your asset. Okay? So these things could happen and has happened. So this is an example of stealing that happened during the Asian financial crisis. Yeah. So since this is small, you can read your slides, but I just read a few of them. The first one is Bangkok Bank of Commerce. This is Thailand. The bank managers move money to offshore companies under their control. Right? So they basically shifted the money outside, but this is done by a bank manager. Okay? So United Engineers Malaysia. This is Malaysia. This incident is very quite famous. I think I'll come back to this again. This is a company called United Engineers. So they bailed out its financially troubled parent, Renon. The company's name is Renon, by acquiring a 33% stake or at an artificially high price. So this United Engineers is a company, listed company, and there is a parent company, Renon. Okay, but Renon is in trouble. Okay, so what they do, the United Engineers buy their shares, right, at a very high price. So what then helps the Renon because it's basically injecting capital into the parent company at a higher price, right? Because you buy shares at very high price, okay? So that's what they did. But if you were an investor in United Engineering, what happened? Well, you're losing money, right? The manager took away your money and helped a parent company which was in trouble. So that's this United Engineers. Malaysian Air System, the chairman used company funds to retire personal debts. Okay. PT Bank Bali, this is Indonesia, managers diverted funds in order to finance a political party. Okay. And Sina Mass Group, Indonesia, group managers transferred foreign exchange losses from a manufacturing company to a group-controlled bank, effectively expropriating the bank's creditors and minority shareholders. So basically, they moved the loss of one company to a bank, right? So that's why if you move the loss to the bank, then the bank's shareholders are hurt, right? The creditors are also hurt. And the next one is Guangdong International Trust and Investment. Asset that has been pledged as collateral disappeared, okay? Su Fun Ceramics, Hong Kong, China, asset also disappeared. Toko Bank, Russia, creditors who may have been linked to bank managers took control of the bank and its remaining assets following default. Yeah. And the next one is Menatep, this is Russia. Following Menatep's bankruptcy, managers transferred a large number of regional branches to another bank they controlled. So this, and there are two more Russian examples. The last two is Korea, Samsung Electronics. Yeah, it's a big company, right? Managers used cash from Samsung Electronics to support other members of the Samsung group, notably Samsung Motors, that were losing money. Yeah, so Samsung is a big corporate group. So in that group, there are many, many companies, right? So Samsung electric, right? Samsung Electronics is famous, right? Because they make phones, right? So, and that is a very successful company, very famous. But then during 1997-98, Samsung Motors were losing money, right? So what they do is they transfer the money, the loss, right? They transfer the money from a successful company, which is Samsung Electronics, to Samsung Motors. This is called tunneling. We'll talk about this again. So therefore, if you were an investor of Samsung Electronics, right, basically your money is stolen, right? In this case, the decision is made by the family. So the family might benefit, right, because they control the whole group. But if you are only an investor in Samsung Electronics, then you are basically expropriated. Okay? So that's an example. And the last one is Hyundai. Managers of Hyundai controlled investment fund channeled money from retail investors to loss-making firms in the Hyundai group. Yeah. So they used the money, they took the money out of an investment fund, okay? And then basically they sold the asset and then used that money and gave it to, or transfer the money into this loss-making firms in the same group. So it's similar to this Samsung Electronics, okay? So these are the things that happen just, around the time of Asian financial crisis. So why do they look at this Asian financial crisis? Well, because it's not because this causes Asian capital markets, but that's one reason. But the reason why they look at this financial crisis is this is when the companies, many companies, are in stress, right? Because it's a financial crisis, stock market going down, some economy is slowing down, right? So therefore, the whole region, especially like Thailand, Malaysia, Indonesia, like Korea, were especially hit by this Asian financial crisis. So most of the countries the companies were in trouble or in stress, right? So they're desperate to do something, right? So that's why some of these research articles look at that particular period, right? Because if the economy is good, if everyone is doing well, then these things may not happen, right? It happens because the firms are in stress. Yeah. Okay. So the last one is accounting standard. So this is very important because it's a disclosure, right? Basically, it's a disclosure to the investors. So if you have good accounting standards, then the investors can find how the company is doing, and also, they can do research on the company, and then, make a decision, right? So if the accounting standard is not good, which means maybe less disclosure, then investors cannot find out what actually the firms are doing. Or if the standard is not good, where accountants or the firm can massage the number, right? So even though there could be a loss, but then they can move the loss to next year, these kind of things, so they can move the numbers around. Yeah. So, so that's why this accounting standard is important. And then LLSB also goes through all these, different items. And I won't go through this in detail because focus is more on shareholder rights and creditor rights. But what they find is, yes, Scandinavian common law, German civil law, where Scandinavia has the best accounting standard, and then common law, German civil law, and somehow French civil law countries always come the last. Yeah. So that's what they find. Yeah. Okay. Yeah, so that's basically the LLSD, right? So what they do is they classify, right, the countries by legal origins. And then they look at creditor rights and shareholder rights and other items. But the message here is that, well, a common law country overall seems to be good, or especially for shareholder protection, I think they are, very strong. For creditors, yes, common law countries are good, but German and Scandinavian countries are, maybe better than common law countries. But again, the French civil law countries, doesn't look good in their research. Yeah, so that's what we find. Okay, so based on this result, right, then we start looking from next week. Okay, maybe we can start this week, but basically what we do next is to see how this, legal origins can affect the financing of the company or the investment of the companies. Okay, so that's what we're going to do. Yeah. So that's basically where we are going. And then this concept, right, of this law and finance can be applied to, other things like, okay, even for like countries that are not in the list, which is basically China, right? So there is an article that we are going to look at, and this article looks at China from this law and finance. Okay, so they do actually do the same thing for China, looking at the legal system, right, creditor and shareholder, and then they analyze about Chinese companies. Okay, so basically we're following or using this, conceptual framework, and then see how financing and corporate behavior, right, is affected by the legal system. Okay, so that's what we're going. Okay, any questions up to here? Is that right? Okay. Okay, then let me just go on and do a little bit to the 5, right? I'm still revising this next slide, so I will, upload the most recent one sometime during this weekend. But anyway, most of the one on the Wattle is almost the same. But I will add something else, which is not in here yet. Okay, so now we are going to look at, particularly in Asia, okay? Okay, so what we do, well, this is just a review, right? Review of typical finance textbook view, which is, firms maximize shareholders' value, but there are agency problems, and then the standard view of finance textbook is this, right? As I said, it's Burrell and Means book. So their view is, well, ownership is dispersed. There are so many shareholders. You can say many small shareholders, right? And therefore, there's a difference or the dispersion between ownership and control, because the managers control the firm, So that's why managers are agents, right, of shareholders. So agents may not behave in the interest of shareholders. May not, right? Sometimes. So that's why we call that an agency problem. So that's what we learn in the textbook, right? But the key point is this, right? The ownership is dispersed, it's very widespread. Okay. And also assumes good legal system and regulation, right? And so this is basically what we assume in the standard finance textbook, mostly American textbooks. Okay. And also market is efficient. Okay. So therefore, the first question is this true in Asian countries? Right? So first you have to ask, how common are widely held firms? Okay? Versus firms that have owners with significant voting rights. Okay? So some owners could control the firm, right? Significantly. We already saw some evidence in the previous table, right? So the next question is, okay, who are these people? Okay, who are these people? So are they families, the government, the banks, or other firms? So those are the things that we have to see first, okay? And the next question is, how do these owners, if they control the firm, how do they maintain their power? So what's the mechanism how they maintain that control? Okay, so that's what we're going to look at. So a simple example is so-called superior voting rights. So this, as I said earlier, I probably said earlier that like a state-owned enterprise or a company that is set up by the government, and the government is the largest shareholder. In many cases, they have superior voting rights, or you can say veto rights. They can veto anything if they don't like it, right? That's because against the national interest. Okay? It's not for the shareholders' interest, it's for the national interest. So that those things could happen. Yeah. So one owner, right, can exercise control with one ownership, okay? Or just one shareholder. But here in Asia, there are other ways that these controlling shareholders can maintain their power. Okay? So this is what we're going to talk about maybe in about 3-4 weeks, is about this ownership structure between the firms. Okay? So basically, one most well-known one is a cross-ownership pattern. Yeah. So this is quite famous in Japan, in Japanese companies, because many of the Japanese companies in a certain group, perhaps maybe a more common name would be like Mitsubishi, right? Mitsubishi, you probably know Mitsubishi Motors, right? They build cars, but then Mitsubishi Motors is one of the companies in the Mitsubishi group. So there is Mitsubishi Band, Mitsubishi Heavy Industries, and all these kind of things. So, so what happens is that the companies in that group holds the shares of companies. They basically hold yours and you hold mine, and it's not just by two. If there are like 50 companies, then they will hold their shares, okay, of each other. So that's basically cross ownership. Yeah. And we'll talk about this, why they do this. Okay, we'll talk about this. And especially in other countries like Korea or sometimes Hong Kong and other Asian countries, there is this pyramid ownership structure, which means that typically the family is at the top, right? And then there's a family owns and controls like 2 firms, and then this next group of firms then controls the other firms. So it goes on, so it becomes like a pyramid scheme. Okay? So that's how they control the group. Okay? So this is quite typical of Korean corporate groups. But this cross ownership and pyramid structure is not, exclusive. It can be a combination. Right? So many Korean groups have pyramid structure, but also cross-holding structure. So it's, you cannot just separate the two separately. Yeah. So, so that's, how this controlling family or the major shareholders control the group. Okay, this is how the mechanism. Okay, so. Now, so this is LLS, they don't have the V, but it's the same set of authors. Yeah, so here it's written out, Laporta, Lopez, de Silanes. Yeah, this is the second author, and then Schleifer. Okay. So they published this paper, Corporate Ownership Around the World, in 1999. So this is after they published the first paper. 1998. So now they actually do look at this ownership structure in this case, they only look at 27 countries. They didn't include emerging countries at that time. And then they look at the top 20 firms ranked by market capitalization. Okay? And then they say that except in economies with very good shareholder protection, relatively few of the firms are widely held. Yeah. So which means that Burroughs and Means, right, image of ownership in modern corporation says, well, shareholders are widespread, but Laporta, Lopez, and de Silanes and Schleifer found that, well, that's only in firms with good shareholder protection, okay? And the rest of the companies, rest of the companies in countries where shareholders are not protected, well protected, have families or the state as the major or controlling shareholder. So that's what they find. Yeah. So, but I'll show you a table. Okay, I'll show you a table, but. Okay, well, let me see. Okay, I'll show you the table first. Okay. Now, this is, okay, you have the countries, right? On the first column, and then the top panel basically looks at countries where there is high anti-director, rights. Which means that the minority shareholders are more protected for these countries at the top half of this table, and the bottom is lower. Okay? So first they basically classify into two, and then in each column it says, first column says widely held, right? So what percentage of the shareholders, are basically dispersed shareholders. Okay, so that's what it means. So the second column is, okay, how much does the family own? Say third column is the state government, right? And then the next column says widely held financial, which means these are the, you can say, banks, and the banks themselves are widely held. Okay, so it's like these are like listed companies. So the next column is widely held corporations, right? So, so when they look at this, or if you look at this, look at the column of widely held. Okay. So, US and UK are the only two countries where the companies are, right, basically held by dispersed shareholders. You can say in UK 90%, in US 80%. Okay, so then I'll go back to this previous page and exactly show what they did. Yeah, so the first part is okay, right? They look at 27 countries and then split the countries into high anti-director and low anti-director rights countries. And then what these numbers show are they look for shareholders that ultimately control more than 10% of the controlling votes. Okay, so I will talk about this next week, what this ultimately means. Okay, but but you can think of like a family, right? A family owns like a group, right? They can control the firm by holding shares, right? But the thing is, if firm A, family controls firm A, and the firm A controls or holds firm B, then family also controls B through A, right? Yeah. So basically, if you look at B, then you can figure out how much the family controls B, even though it's through A. Okay. So but I'll show you this in detail next week. But that's what it means by ultimate control. Okay, so then they look at the company shareholders that control more than 10%. They look at 10% because 10% cutoff is fairly large, but it provides a significant threshold, right, of votes. And most countries, if it's over 10%, you have to disclose them, right? There's a mandatory disclosure. So that's why it's easy to find out. Yeah. So that's why they put this 10% threshold. Yeah. And so therefore, you can see, right, other than US, UK, the family in the state, right, either family or the state are the largest controlling shareholders, okay? Like Argentina is 65% family, right? I mean, this is basically saying that of the controlling shareholders, which has more than 10% of voting rights, they have 65%, yeah, or they own 65% of the firm. Okay. And if you go down, like state, right? State, yeah, you can see that like Norway, New Zealand, Singapore, yeah, these have fairly high state ownership. Okay? New Zealand, you might feel a bit odd, but they had quite a few state-owned firms around this period, and they have privatized later on. Okay, so therefore the state ownership is probably lower right now, but they had quite a few state-owned companies. Okay. And Singapore again, right, the state has fairly large ownership, and this probably is still true, yeah. But it's not, these Singapore companies are not necessarily state-owned, but it is state-controlled because they are held indirectly through like a government fund. It's called sovereign funds. So sovereign funds, which is controlled by the government, they invest in these Singapore companies. So that's how the government controls, okay? So that's why in Singapore this is pretty high. Okay? But so then if you look at this list, right, or this table, you can see how US, UK are the exceptions. Yeah, they are the exceptions. And this, we're not talking about emerging countries. These are all, you know, developed countries. So, right, especially like if you look at this part, right, you see almost none, right? I mean, Switzerland like 50%, right? But I think, or in Switzerland, 40% family. Yeah. So you can see that the Burl and Means view of ownership is only for US and UK corporations. Yeah. So that's why once you step out of these two countries or two markets, the picture is very different. So imagine, right? You work for, let's say, a bank or investment company, or maybe doing your own investment and trying to find a company to invest, right? Then you probably would be worried, right? If you're investing in a company where like a family owns more than 50% or the state owns more than 50%, then you might start to worry, okay, what would these people can do for you, right? If you're the minority shareholders, right? So for state-owned, well, you might be, you know, affected by the government's policy. But also, you know, if it's family, then, you know, things like what happened, I showed you in like the stealing, right? These things can happen. So that's why, as an investor, there's a good reason to worry about these things, okay? So that's where, you know, our project is coming from. Yeah. So this is basically what it looks like. Let's see. Okay, any questions on this? Is this unusual, or were you surprised to see this? No? Because you're from the region. You can expect, okay. Yeah, but if you show this to someone in US or UK who only knows about US-UK market, then this can be surprising, right? So the views of, if you learn finance from like American textbooks that we use, then, you know, this is the world that you're looking at, right? And then in the textbook we talk about agency problem, right? But then there are other problems, right? Not just the agency problems if you have this concentration of ownership. And we're looking at like other, you know, developed European countries, the same thing, right? Okay, so this is basically, how we are going to start, and then, okay, this is an example, but I think I'll go, let me see. Yeah, I think I'll let you go home today, yeah. And because if I go further, then I cannot find a good place to stop. So this is like the entrance, entry point. Do you have any other questions? Anything about the project or anything? We can talk if you like. No? Okay. I guess you, sorry? Project. Yeah, do you have a question about the project? Yeah, recommendation of the format. Well, recommendation or the format is, I have given you, right? It's written on that slide. Yeah. For the recommendation, yes, I also have written that. But recommendation is that, as I said earlier, that because, you're looking at different markets, right? And then there are so many companies that are listed. So therefore, I'd advise you to just go trial and error. First pick 3 or 6 companies or maybe 10 companies, and then just go through them. And then if they, because you have to pick the good ones and bad ones, right? So therefore, if you find some of the good ones in those first 10, then just keep them, and then go to the next one, and then see if you can find the bad ones. Right? But if you cannot find it, then just enlarge your search, right? I think that's probably a better way. I know I have had project that went through every company. Yeah, of course that would be great if you can do it, but eventually you pick 6 companies, right? Yeah. If you had like a huge computer system or database, of course you can put all the companies and then do the sorting and all these things. Yeah, but I don't think you can do this. So, but I think it's better for you to go through the financial statement individually, because that is what I'm expecting you to do, because in that way you will learn about the companies, because you'll see the numbers, who's the owners, right? And then ask questions, right? Yeah. I think that's part of the objective, to go through these financial statements, and then it's basically a hands-on experience. If you have not done this, right, it's a good experience for you to do this, okay? If you had invested in stocks before, then you might have done this, right? You might have gone through financial statements before you invest in a company. But if you had not done it, then this is a good opportunity to just do this. So that's basically the suggestion, and that's one of the objectives of this project. Your experience, right, of doing this project, the process is important. Okay, any other questions? Okay, thank you. Okay. competitors not because it's a reorganization of the company because they have competitors coming back, but they cannot get the money. So no stay on the asset means the creditors are protected, right? Because they can go in and see there.
Yeah. Okay.
Yeah. The wording is a bit confusing.
Yeah. No.
Yeah. So that's what on the plan application. Project. Oh, plan. Yeah. I think we got you said that we have every day. Yeah, that's a little bit. So you have to get together and think about the plan. So it's fine to start building now with the plan. Yeah. But anytime, because I want the group to get together. That's really just maybe what will happen or how they want to it's more like until we this right up this kind of basically what to what exactly is you don't have to, but you can say,